Welcome to The Point of View. This is your favorite current affairs show on television here on Channel 1. Here on The Point of View, we pick the right topics, we get the right guests, we ask them the relevant questions on issues that matter to you. It's a very legal heavy week in Ghana. And of course, the Supreme Court has been hearing the matter involving the majority leader, the Speaker of Parliament, the 4 MPs whose seats are under contention. There was a very important decision that happened earlier in the day. We'll bring you part of that on the show today. But before that, the flag bearer of the Ghana Freedom Party, Madam Akua Donkor, kicked the bucket a couple of days ago. And that has set in motion a number of issues. Tonight we ask, what does her death mean for the election and possibly for the ballot paper? Because dead men can't talk, neither can dead people be voted for. I was speaking to a legal practitioner to help us look at the various legal issues that arise from the death of a presidential candidate 40 days or so to an election. Stay with us. So tonight we start with the matters arising from the death of Madam Akua Donkor. I'll be speaking to lawyer Sammy Darko to help us understand what is at stake and what the possible scenarios could be depending on what the party to which it belongs does. But let me start with the EC's own letter. So Sammy Tete, the deputy chairperson of the EC in charge of operations, yesterday, 29th October, sent out a press release. I'm going to read it as I see it. Death of 2024 presidential candidate, Madam Akua Donkor. The Electoral Commission has today received information on the unfortunate passing of the presidential candidate of the Ghana Freedom Party, GFP, Madam Akua Donkor. May she rest in peace. While the 1992 Constitution and the Public Elections Regulations 2020 CI 127 are not clear on processes to follow in the event of the death of a presidential candidate, Article 54 of the 1992 Constitution provides as follows, quote, where at the close of nominations, but before the election, one of the candidates dies, a further period of 10 days shall be allowed for nominations, unquote. The Commission has since informed the Ghana Freedom Party to make arrangements to nominate a new candidate and inform the Commission accordingly. In the meantime, the Commission has suspended the printing of presidential ballot papers, which was near completion. Thank you, signed Sammy Tete, Deputy Chairperson, Operations for the EC. Now, Sammy Darko sent this legal education to his friends in the media earlier in the morning. So whilst I was on air this morning, he sent us an article titled Implications of the Death of the GFP Presidential Candidate, a Legal Perspective. I don't want to read the whole thing because I have the man here with me. But Sammy, thanks for joining us. Good evening.
Thank you, Bernard. Good evening.
So what prompted your interest in this matter to write this short legal educative piece on this matter? What about it caught your attention?
First of all, 2 things caught my attention. The first one had to do with conversations around implication when it comes to balloting in terms of the ballot positions of the various parties. I had heard a lot of discussion that it may mean that number 8 becomes number 7, or number 13 becomes number 12. Then the second one that piqued my interest was the letter by the Electoral Commission, particularly because they make reference to the Constitution and also admit that the Constitution does not provide a guide as to how this may be resolved. And so these are the 2 things that piqued my attention into this matter. If you allow me, the Electoral Commission rightly goes to the Constitution, Article 54, and they quote the provision of Article 54, which I think you've read. But they did not quote the entirety of Article 54. They ended around nominations. And if you permit me, let me quote the entire provision of Article 50, Clause 4. It says, where at the close of nominations, but before the election, one of the candidates dies, a further period of 10 days shall be allowed for nominations. And where the death occurs at any time within 25 days before the election in that constituency or unit shall be postponed for 21 days. Now, my reading of the Constitution tells me that this particular provision is not a provision for presidential candidates. Mind you, when it comes to the language of the Constitution, you will see that it talks about death of candidates. Now, when you read it further, it will say that in that constituency or unit, and we do know that parliamentary elections as well as district assembly elections are what I reference when it comes to constituency or unit. And when it comes to presidential election, you will notice that it's a two double persons contest, whereas the parliamentary one is a single person contest. So for me, Article 54, it's referencing a single person contest than a double persons contest. Now, when we say a double person contest, one of them is a presidential election. And if you take Article 62(3), you notice that when it comes to a presidential election, two people are the one contesting on a single ticket. It's not one person. So you have the president, then you have the vice president. That's why if you read Article 62 to say a candidate for the office of vice president shall be designated by the candidate for the office of the president before the election of the president. And if you go to even 4, it will say a candidate shall be deemed to be duly elected as vice president if the candidate who designated him as candidate for election to the office of the vice president has been duly elected as president in accordance with the provisions of Article 63 of this Constitution. What that means is that when it comes to presidential election, there are two people on the ticket. And the framers of the Constitution were very clear in how they were going about it, so that even in an event of one person dying before the election, I'm of the considered opinion that the vice presidential candidate takes over automatically, which might not even need EC to even write to any of the parties to say, can you bring me a candidate? Because remember, if they were to have won the elections, the vice president and the president are deemed to have been duly elected. And when one dies, the other person takes over. So in this instance, if I'm reading it very well, then it should even be that the vice presidential candidate automatically should take over as the presidential candidate. Then in consultation with that political party, they could then now nominate a second person to be, say, the vice presidential candidate. So my reading of the law is that the provision we are quoting, that is Article 54, may not be the one which should apply in terms of a presidential election. And I'm happy the EC even admits that there's no guidance. And my position is that, in fact, this is a novel situation because the Constitution did not clearly demarcate in terms of the processes to follow. That's why the Constitution also gave the Electoral Commission the power to come up with what we call a constitutional instrument so that it could lay out how such a scenario could be cured. Unfortunately, the CI 127, which we are using, is inept and did not anticipate the death of a presidential candidate. So if you go through, I'm sure subsequently when we are talking, you see that they cater for so many things, but they never catered for a presidential candidate dying before the election.
Okay, let's pause there. I want to ask around the Article 54, which you believe applies to parliamentary and unit, because it's explicit. They use the word a constituency or unit. I had an argument on a couple of days ago that for the presidential election, the returning officer is the chairperson of the EC. And since there are returning officers for each constituency, if the chairperson of the EC is the returning officer for the presidential, the country is taken as one constituency. So in that sense, you can apply Article 54 to a presidential election on the basis of the country Ghana being one. Because when you add the number of votes in the country, you determine the winner. What do you make of that?
Well, that's the beauty of law. Others may want to come from that point of view. But for me, and I think other lawyers may agree with me, that would be stretching it. Because, yes, we say it's so absurd for us to say that the whole country is one constituency. Other than that, the Constitution wouldn't have also said that the country should be divided into constituencies where people will now contest. Now, let me stretch it further. See, when a candidate dies or a parliamentary, an MP dies, you know, the election will be held for that constituency that the candidate died. But if, say, God forbid, but a president dies, let's take when the former president Jonathan Mills died, we were not going to hold elections for different constituencies, but then the vice president automatically becomes the president. And then the vice president, who is not the president, will then appoint another person as the vice president who would then be approved by parliament. So it does not occasion another election. That's why I'm saying that this is a double contest, a two-person contest. So the two people are inseparable in a way who are then contesting. So you cannot stretch it to say that because we have loosely said that the whole country is one constituency, then this provision applies. Other than that, if you go ahead, see the last part of it. It says that, and where the death occurs at any time within 25 days before the election in that constituency or unit shall be postponed for 21 days. Are we saying that if a presidential candidate was to die 25 days before the election, then we are going to postpone the presidential election for 21 days and hold it, say, on the 28th? That would be absurd. That would be too much of a cost for the country. This problem has arisen primarily because I said that the Constitution gave the Electoral Commission the power to come up with a constitutional instrument. And the constitutional instrument we created is inept. We did not anticipate. And that has been a major problem in this country, where sometimes we do not take into consideration major scenarios and things that could happen to us. So this happening is now going to help us to chart a new path. And I'm thinking that when in the next election, when we are developing a CI, we may now want to take our time and go through all the scenarios that could happen that we may need to take care of or cater for.
Let's look at the CI 127. Which part of it comes closest to trying to deal with the death of a candidate? Let's just look at that and see why you think it's inept. And then let's look at the PNDC law you quoted as well in your article, the 284. But let's start with the CI. So you're saying that the CI we created for the election 2020, CI 127, even though it deals with the death of a candidate under Regulation 17, it still did not contemplate a presidential candidate dying. I have portions quoted. If you can read that and walk us through that.
Yes. So you rightly said CI 127. If you look at Regulation 13.4, it repeats what is in the Constitution. So let's start with Regulation 13.4, which says that where at the close of nominations, but before the election, one of the candidates dies. One of the candidates dies. A further period of 10 days shall be allowed for nominations. So it's repeating what is in Article 54. Now, I'm saying that Regulation 13 pertains to instances where the nomination period has concluded, yet a candidate passes away shortly before the election. And when you look at Regulation 17, on the other hand, it addresses a situation in which a candidate dies on the eve of the election. Then it says that when proof of death is presented to the returning officer before polling commences, it then details what should happen. This is what I'm trying to say, that we could have developed a similar one for the presidential elections. But this will apply to, so you see that it becomes Regulation 17.2. It says that upon notification, the commission must adjourn the poll, granting the candidate's party 10 days to nominate a replacement. If the deceased candidate was an independent, no replacement is allowed because it's independent. So once he dies. Then 4 says that if a political party nominates a new candidate, the commission shall adjourn elections in the constituency of the deceased candidate for 21 days from the date of the new nomination. So if you look at Regulation 17 of CI 127, it clearly lays down the procedure and the processes where a candidate dies on the eve of the election and what will happen. But if you look at 13, Regulation 13, which comes close to what we are talking about, that has to do with a person dying before the election but at close of nomination. That one doesn't detail out any processes to follow. But even that one, my argument is that this one, 13.4, will apply in situations that affect parliamentary candidate or district level elections or any other public election, and not necessarily double ticket candidates, where when one person dies, the other person must automatically assume the new position of the candidate. And then in consultation with that party, they could then come up with a vice presidential candidate. That's why I also found it irregular for the Electoral Commission to say that they have sent communications to the JF party that they should fill the vacancy, because my understanding is that when it comes to presidential election, it's a two-party, it's a two-person's ticket. So when one dies, the other one should automatically take over. Yeah. And then the party could come up with another person.
Let's deal with that point briefly. The point about the automaticity of the vice replacing. The argument is that the party nominated Madame Akua Donkor, or they voted for her or used a means to choose her, and then she chose her running mate for the election. So in a sense, the mandate is with her, and the party was the body that nominated her. But in her vice, she just chose the vice. So if she dies, you need to go back to the party. So maybe the party can say that, well, we are renominating, or we are renominating the vice, but it shouldn't be the easy. That automaticity is a problem, which is probably why in the independent candidate case for the parliamentary, when the independent candidate dies, because I mean, presidential independent candidates also have running mates, right? So I'm just thinking that if it was an automatic issue, why doesn't the independent presidential candidate then also have their vice replace them? Or is it your concern that because this is for parliamentary, independent doesn't, running mate doesn't arise, which is why in the presidential case it's different?
You've made a very important argument as well. You realize that when we read Regulation 17, it talks about, in the case of, say, an independent candidate, it says that there will be no need for a replacement. But that's why I've insisted that this applies to parliamentary or any other elections, but not presidential, because as you have rightly said, if it comes to a presidential, it will be two persons tickets. Now, I understand your argument very well that the party elected one person and then that person picks a running mate. But if you take the filing of nominations and the affidavits and all that they go through, when they win elections, that person becomes the vice president. Whether some people in the party did not directly vote for the person or not, that person becomes the vice president of the country. So the system has been done such that when you win election, that person takes over. And if you are in power and unfortunately you die, that person becomes the president. So the same argument could hold for the fact that you have already filed your nominations and you have attached that person as your running mate. And you've sworn an affidavit to that. So it shouldn't be that the party now then decides that we are going to now nominate another person. But I mean, that's my considered view. A political party may want to decide that, well, they would want to spend more money, they want to go through conflict, they want to go through all those motions and then come up with a new person. It means that they don't even trust in the vice presidential candidate to be a presidential material. That's how maybe I would look at it in terms of my way of interpreting it. But suffice that to say, I think that that shouldn't take away from the fact that I believe that currently we don't have any law or any procedure to sort of cure what has just happened. But the other important matter, maybe we're going to come to it, will be that others have said that there will be change in positions.
Yeah, I want to come to that, because for that one, I think we have to move ahead, because first I'm dealing with the issue of what we must do directly. But you made a point that I need to clarify. So you are saying that your first reading, the running mate should replace the dead candidate, and then the party should supply another running mate to fill the void. That's your first. That's your first reading of this.
Because it's a two-person ticket, and when one person dies, it doesn't detract from the ticket. It doesn't nullify the ticket, because it's a two-person ticket. I must repeat. So that person now should become the presidential candidate. Then, in consultation with the party, they should also elect a running mate. I'm saying that all these are legally permissible, and these have arisen because we don't have clearly laid down processes and procedure in any of
but Sammy, let me deal with that for 2 seconds. 2 seconds. Because the presidential candidate's filing of nomination has a specific procedure it goes through, and its running mate is just nominated, and possibly the requirements may not be the same, do you not think there's a problem there? Because I suspect that if GFP presents Akua Donkor to EC, this is a presidential candidate, she pays a filing fee, she presents her tax returns, and I think she needs specific number of signatures. And then she also presents her running mate as part of what she's doing. I don't think the running mate actually pays the amount. Neither does the running mate need the signatures that the candidate needs. So my assumption is that the EC treats the presidential candidate as one person, and then the vice supports to make the thing complete. But once the candidate dies, even if there's an automaticity to the elevation, then the running mate must do those same filings if it requires. Do you understand my point? Because if I'm a delegate signing for...
Yeah, I understand your point so well, but we'll go into the realm of absurdity, because remember, it's a two-person ticket.
Okay.
Everything that was done together.
Okay.
So all that they needed to do were done together. I must be frank that, because I've not seen what was filed, but I think that the vice presidential candidate also must show the tax returns and all those processes. And I think that both of them would have gone throughout all the constituencies across the country to get the signatures and all that. And that is why when the person becomes president, the other person automatically becomes the vice president. I think that if we look at it that way, then we will see that the two of them did it together and not a one-person show.
All right. We'll take a break. When I come back, I want you to examine the possible scenarios, especially because the EC has taken a certain position, and that position means that depending on what the party does, there could be possible outcomes. So I want us to deal with that when we come back. This is the point of view. Today we are not in court, we are in a classroom trying to understand what the potential ramifications of the death of Madam Akua Donkor, who's the flag bearer of the GFP. EC has written to the party to submit a nomination. That doesn't end the matter. We'll be right back. My guest is lawyer Sammy Darko. Stay with us. Welcome back. So the point of view tonight is dealing with a very interesting situation. Of course, the unfortunate demise of Madam Akua Donkor, the flag bearer of the GFP, a couple of days ago. EC has written a press statement saying that they have informed the Ghana Freedom Party to make arrangements to nominate a new candidate and inform the commission accordingly. So that new candidate could be the running mate, or it could be somebody else. Now, Sammy Darko's view is that ordinarily it should have been a running mate, but EC's view seems to put the onus on the party to make a decision. Now, Sammy, based on what the EC has started, it appears there are many scenarios, right? So the party could simply say, we are presenting a person. It could be the running mate or somebody else. And then the EC will do it in 10 days and quickly sort of maintain the number. What number? The number, because the party chose the number, right? So in the case there's a nomination of a candidate, the number 3 of GFP does not change, correct?
The first scenario is that if they present the vice presidential candidate as the candidate, and then he, together with the party, nominates another person, what that will mean is that the party could remain on the same position. Then the party colors and logo could be used. And together with an agreement with the EC, they could cancel the name and the picture of the deceased person and then the election will go on.
Hold on. In that scenario, the logo remains, the picture is, but the word used is cancel, because once you print a ballot paper, anything else you do to it may invalidate it, because you get my point. The ballot paper, once it comes out of the print...
But this will be done together with the political parties. So the political parties will agree that when it comes to number 3, the candidature is cancelled or crossed. So if
I'm coming on. I'm not invalidate. What I'm saying is that, can't they just leave the woman's picture there with the party logo? But we know that it's the running mate who's being voted for, because once you tamper with, because I feel like the problem will be, once the thing comes out of the printing machine, anything you do to it could compromise it, because if there's even a dot somewhere, they could call it as a sport ballot, right? So maybe
I agree with you. I agree with your scenario as well, but I'm saying that these are all scenarios, and the EC may want to begin engagement with the political parties, in my opinion. When we reach an agreement, then it no longer becomes unlawful. It becomes unlawful when some people don't agree and they are insisting that this should be done and that should be done. But that's why I said that with these scenarios, it always depends on the EC reaching an agreement with the political parties. So if scenario 1, what you said is also true. If scenario 1, instead of crossing, they decide to leave it like that, but they do know that the vice presidential candidate will now be campaigning that I am the presidential candidate and it's the same party, that could work. The second scenario could be where they elect totally new person, and then he also gets a vice presidential candidate. We could maintain the same, of course, we can maintain the party logo remains, and then the deceased presidential candidate can also remain, and the person will also campaign. But where the party insists that we are not going to field any candidate,
that's where it becomes complicated. So if the party says we are unable to pick a new candidate in 10 days, and we are unwilling or unable to use the running mate, this is where it becomes very murky, right?
Yes, this is where it becomes murky, because then what it means is that we are no longer, I'm using the current scenario, we no longer have 13 presidential candidates and running mates. We now have 12. Now, if we have 12, what will happen is that we can also decide another 2 scenarios, which is that we can maintain the status quo and say that we are not going to touch that of number 3 because they are not in a contest. Again, the parties could agree that the EC could cancel number 3 with whatever ink. It's just now you said that you don't agree with the ink, but I'm saying that anytime people agree to do something, then that thing does not become illegal anymore. That is if somebody, unless someone contests it. But if they agree, they could cancel it. That's scenario 1, so that everything remains intact. But if they don't agree and they say that no, we don't agree because we don't want any additional pen or ink on the ballot paper, so let's print a fresh ballot paper without the number 3 candidates in it because they no longer are part of the elections. Then that is where the issue arises. And the issue arising will mean that now we have 12 presidential candidates. And for me, my considered opinion is that then there has to be fresh balloting, because then we would have canceled one. The reason why there has to be fresh balloting has to do with what we call fairness. The fairness in the sense that everybody has had the chance to campaign on their numbers. So number 1 has campaigned, number 8 has campaigned, number 13 has campaigned. Now, if you decide that, okay, I'm going to let number 1 remain constant, but I'm going to push those down to fill up the vacuum, then what it means is that you will be disadvantaging, the rest will be disadvantaged because their numbers now changes. And they are the ones who need to now change all their campaigns in terms of paraphernalia and messages and everything. And that would be unfair. Should anybody take part, there's the likelihood that that person may get a good argument to make in court. So in that scenario, then we need to do a fresh balloting so that no one has an advantage. So if the last scenario happens, the Electoral Commission must necessarily hold fresh balloting to determine fresh position, but that would be so costly to the state. One, we are printing fresh ballot papers, and two, the candidates will have to find money to do fresh campaigns.
Right. So Sammy, in a sense, you are saying common sense must prevail over common law in some of these issues. So let the common sense thing happen so we save money and save time.
Instead of using common sense, I would say public interest.
Wonderful.
Because remember, whatever money the EC is spending is not someone's money. It is you and I, our taxes that are being given to the EC to spend. So as a country, do we want to spend so much money to print everything afresh? If people say that for peace to reign, democracy is expensive, so let's go for it, that is also a good deal.
All right.
But if people say that let's try and preserve money because we are in hard times and judge with the parties and come up with a good way forward, that's also a good one. My suggestion is that we should go for the one that is in the public interest. If the public interest is that the parties are so at each other's neck that they cannot agree, then we should do an entirely new balloting, an entirely new printing.
All right.
But if they could agree, then let your common sense argument prevail.
Thank you, Sammy Darko, lawyer Sammy Darko, with that very interesting scenario analysis of the death of the presidential candidate of GFP, Akua Donkor, and what the scenarios and the possible outcomes are. We'll come back and go to the Supreme Court and bring you highlights of what occurred. My colleague Fred Jabano was following closely the proceedings. He'll bring us the quick overview, and then we'll take you into the court to tell you or show you some of the key flashpoints that occurred in that massive case involving the Speaker of Parliament and the matter of the 4 vacated seats. Stay with us. Welcome back. This is still The Point of View, a very law-heavy edition. We just finished with lawyer Sammy Darko on the possible scenarios regarding Akua Donkor, GFP flag bearer's death. Now, the Supreme Court was very busy today because the Speaker of Parliament had gone to court to ask that the Supreme Court overturns its own stay of execution order it granted on the 18th of October. Fred Jabano has been following the matter closely. So this has been very confusing for me. It seems as if there are like 3 or 4 cases. So just walk me through. What was the decision in what was the issue in court today? What were they looking? What were they doing?
To be able to understand the issue in court today, I'll start from the beginning. This case started on the 15th
of October.
Good. When the majority leader Alex Afenyo-Markin went to the court with a writ for an interpretation of Article 97 G and H of the Constitution, where it talks about the fact that when a person vacates or who is voted into parliament on a particular party leaves the party to contest as an independent or leaves the party to join another party, you have vacated your seat in that parliament.
So he wanted an interpretation of that in the Supreme Court.
In the Supreme Court.
This was the 15th.
This was
even before Speaker Bagwin did his ruling.
This was even before Parliament came to return to.
So he did this. So this is the beginning of all of this.
This is the beginning of all of this.
Good.
When this happened, when he filed this particular writ, he added an application for injunction to stop the Speaker from making a ruling on the matter.
Until this issue was heard.
Yes. Don't forget that before then, the weekend, Haruna Idrisu had raised a concern at the party rally that they were going to move for the removal of these 4 MPs.
Okay.
So Alex Afenyo-Markin goes to court to file the writ for an interpretation of Article 97 G and H. They get to Parliament. The minority leader, Dr. Kesa Atoforsen, moves the motion.
He makes a statement.
He makes a statement asking the Speaker to just look at previous rulings by a former Speaker and get the people to vacate. The Speaker did not take a decision on that particular day. There was 2 days he gave and came back on the Thursday and ruled that he agreed with the minority leader and also supports the decision by the then Speaker Akua and ordered that the 4 MPs, 3 who had left to be independent and 1 independent who had left to join the MPP, to vacate their seats.
Good.
After this particular issue, the majority leader, Alex Afenyo-Markin, again now goes back to the court the next day.
Okay.
And goes to tell the court.
This is now the 18th of October.
This is the 18th of October. Goes to tell the court that we want you to stay the decision of the speaker. But instead of going on notice, they went ex parte.
So without notice or recourse to the other side. So this is the Friday now?
This is the Friday one. The court hears the case and rules on that particular ex parte motion.
So they basically do a stay of execution on Speaker Bagbin's
ruling for the 4 MPs to vacate their seats.
Wonderful. So far, that's where we are.
So the court stays that decision. That's the second one. Then Speaker Bagbin goes back to the court on the 22nd, the morning before the return of Parliament, after he had made the ruling that the 4 had vacated. Goes to Parliament through his lawyers, to court through his lawyers, to file another application for a review of the
stay of execution,
asking the court to overturn its own decision. So this is where we find ourselves now.
When you went to court today, it was to consider Speaker Bagbin's
application asking for the court to overturn his own ruling.
But I'm told that before that, they made another preliminary argument.
Yeah, so at the beginning, there were 2 preliminary objections which were raised, one by the Attorney General, one by the lawyers of Speaker Bagbin, led by Tadio Sori. The Attorney General was of the view that there were 2 averments in the averments of the Speaker, which he felt were insulting to the court. So he wanted the court to strike out those 2 averments. The Bagbin team also said that there was a justice of the Supreme Court who was part of the panel, Justice Jaiu, who they believe was a member of the MPP before coming onto the bench. And they did not believe his neutrality in this particular matter. So they wanted him out of the panel to be replaced on the panel. The court took a break, came back, dismissed the first objection, dismissed the second objection.
So 1-1?
1-1. The court was of the view that the justice of the court who was on the panel had gone through vetting. Everybody had believed that he was going to do his work fairly, so there was no need to come and raise the matter now. He was no longer a politician, so there was no need to come and raise the matter now. So the court dealt with that. Then now went into the argument of Speaker Bagbin's application for an overturning of the decision of the court.
Can we see some highlights of that?
Yes, let's look at the argument.
So this is by Tadio Sori.
This is by Tadio Sori and Godfrey Dame.
Attorney General proposing that.
Yes.
So Tadio Sori's argument for Speaker Bagbin is that overturn your own stay of execution.
Yes.
And Attorney General says, no, don't do this.
Yes. And they were just based on 3 principles. Even though there were a lot of grounds, you can just break them into 3 different ones. Jurisdiction, service, and a rule of natural justice. Jurisdiction being that the Speaker's lawyers argue that the Supreme Court did not have jurisdiction to hear the case because they believe that, according to them, Article 99 was the right forum where the High Court will now determine the vacation of...
So this should have gone to the High Court, not the Supreme Court?
Not the Supreme Court.
Okay.
2, the service on the Speaker was done illegally based on certain administrative agreements between the Speaker, how to serve the Speaker and when he's going. And the third is the issue of the natural justice, which had to do with the issue of the majority leader going ex parte. They believed that they needed to be heard. So this was the 3 arguments.
So let's take some highlights of this and then come back and see what evolved after that.
Mentioned G, but they never mentioned H. But we were all proceeding as if it was there. And that was what I was telling you.
You may have been proceeding, but we were dealing with G.
Very well, very well. My Lord, actually, under the rules, he's entitled to amend. It's just that because of the agency of the circumstances. Otherwise, I would have taken the point very seriously. Because when you apply it, some of the facts will
Mr. Sorry, stop it. Attorney General, do you have anything to say?
But it's safe to say that indeed H is very much part of the controversy, and my submissions actually alluded to H as well. But then also, of course, my lady, I'm always inclined for an expeditious determination. My lady, but the court would note that Rule 53 of CI 16, with all respect, makes provision for a hearing of the matter. My respectful view or submission is that if the plaintiff, the first defendant, will be given the opportunity of filing his case by 6th November, really, there will be nothing wrong, with all respect, if we come for a hearing on the 7th, unless 7th is not convenient to the court, and then the date for judgment can still stand. I think that in a matter of movement as this, in a matter where the public is really interested in it and all the cameras are, with all respect, it will be a little bit, if I may hesitantly use the word, incongruous for us to just adjourn straight away for judgment without a hearing, especially when same is enjoined by the rules.
Thank you, Attorney General. So you will address us on the
7th November?
On the 11th. Yes.
Okay.
And then we will adjourn for some hours for judgment.
Very
because we would have had the opportunity
of considering
all that had been filed.
Very well, respectfully. That's all. Thank you very much.
So that was pretty heated.
Yes.
So what did the court do after that then?
So now the court needed to make a ruling on the matter. Mm-hmm. The court also decided to rule on the three main points I mentioned: jurisdiction, service and the rule of natural justice. On jurisdiction, the court indicated that they were clothed with the jurisdiction to hear the matter. They cited Article 2 of the Constitution, which deals with enforcement, and Article 130, which deals with the original jurisdiction of the court, and also explained that when you look at the case which was brought before them, even when you send it to the High Court, there's an issue of an interpretation
which will come back to them.
Which deals with 97 G and H. So the case would eventually come to them. And based on that, they do have the jurisdiction to hear the case. So on the matter of jurisdiction, they dismissed the arguments of Speaker Bagbin. Now, on the matter of service, the court was of the view that administrative actions do not do not override the law or the legal processes. Per the legal processes, the Speaker can be served anytime, apart from when he is going to Parliament, in Parliament or out of Parliament. So the Speaker can be served
So
anytime.
they disagreed with Bagwin's people on that too?
What the agreement between the Speaker and the Chief Justice was just administrative. And even that, the Chief Justice went on to explain that even in the administrative statement they issued, there was one part of it which says that it was only the Speaker who can be served on Mondays. On any other day, the Speaker can be served through the legal department of the House. So that was also addressed and dismissed.
And then what about the issue
of the issue of natural justice?
Yeah.
The court states clearly that there are some times when there are exceptional issues. Mm-hmm. And in this case, there was an exceptional issue in the sense that when they looked at the arguments by Majority Leader Afenyo Markin, there was a part which had to deal with people losing representation. So the constituents who would not have representation till January 2025, because they cannot hold a by-election.
So they will be injured if this ruling was not stood aside while the matter was heard.
Exactly. The second one was the fact that the people themselves, the members of Parliament involved in this matter, could also be injured, because if the court comes back to rule that that particular interpretation goes in their favor, they would have lost their salary, they would have lost so many things. So they'll also be injured. So in the process of waiting for the interpretation, they believe that it was only right with these exceptional issues to stay the matter.
So basically, the Supreme Court says we agree with ourselves.
Yes, they
was it
agree
the same
with
panel that sat on the original issue of stay of execution that sat on this, or the panel was
almost
different?
Everyone was
same panel?
Not the same, but about 3 or 4 of them
were changed. All right, so let's listen to what the CJ said in relation to the judgment or the ruling on this matter.
Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it. This court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court's orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last. Compliance would also have enabled this court to dispose of this case by this week, including the question of whether the suit is competent in form or the jurisdiction of this court has been properly invoked. It is important, and the question of whether the jurisdiction has been properly invoked is different from whether the jurisdiction exists. It's a different legal question. It is important to place on record that both the plaintiff and the Attorney General have complied with these orders, and this court is able to complete hearing of this suit if the Speaker chooses to file no processes. For the above reasons, the application is refused.
The CJ has made her ruling clear, or the ruling of the panel. So, but we understand the substantive matter has been adjourned to when?
To the 11th.
So on the 11th of November, yes, they will hear this. So what's the substantive matter now?
So now the substantive matter has come to go back to Article 97(g) and (h) for an interpretation of that part of the Constitution. So
the original thing, the majority that sent,
is what is going
they will
to
hear that matter
yes,
on the 11th.
Actually, the court wanted to even hear the case and make a ruling on Friday. But because the lawyers, the Speaker's lawyers were not ready,
they said they hadn't filed their own response. Interesting.
So the court had to give a longer date to hear and rule on the matter.
Thank you, Fred. Tete Jabano, it's been a very busy day in our courts, the Supreme Court, overseeing very delicate matters involving the Speaker of Parliament and the matter of the majority leader. Thanks for watching. Earlier on, we discussed the GFP flag bearer's death and the implications legally for the ballot. All of this and more we will bring you on subsequent programs. My name is Bernard Avle. We'll see you next time. Bye-bye.